Hi, this is Neha Nagpal and Malak Bhatt from NM Law Chambers. We're going to be discussing the bail jurisprudence that has recently been laid down by the Honorable Supreme Court of India in three interesting cases. The first being Siddharth versus the state of UP, the second being Amanpreet versus state, and the third, what is now known as the Until Guidelines. So basically, the view taken by the Supreme Court in Siddharth versus the state of UP was where they discussed Section 170 of the CRPC that post filing of charge sheet, judicial custody is not required unless the special circumstances require for the same. The same view was then amplified in Amanpreet's case, where Supreme Court once again interestingly held that post filing of charge sheet there is no need, no purpose is served for judicial custody. Then came the Until Guidelines, which lay down a sort of comprehensive um, category of cases to be considered for the grant of bail post filing of charge sheet. Malak, what's your view?
So let's just step back before we get on to the until guidelines. Interestingly, these three judgments have been granted by the same bench, which I believe were trying to set at naught the practice which has been prevalent across various states, which is that the moment a charge sheet is filed and the person is produced before the court, he is necessarily taken into custody. For example, in UP, the same practice is followed. So while the court was trying to act benevolent when it came to interpreting section 170 in Siddharth, followed by Amanpreet, which discussed the very uh, non-requirement of taking people into custody until to some extent has now created anomalies with the way the guidelines are framed. And despite the fact that after two judgments, the court was trying to negate this practice of taking people into custody upon filing of charge sheet, especially when not arrested during police investigations, probably until it has set the clock back a bit. So I think it's better if you can explain what the categories in until are.
So Until lays down four categories. Category A is those cases where the punishment is less than 7 years. Category B are those cases where the punishment is 7 years or more, which is 7 years, life and or death. The third category is special enactments such as the PMLA or NDPS. The fourth is this kind of sui generis category now, which is economic offenses not covered by special enactments. So in cases of category A, which is punishment less than 7 years, bail post charge sheet is almost for the asking, as per the Until Guidelines. In cases pertaining to category B, which is 7 years of punishment for 7 years or more, and category D, which is economic offences not covered by special enactments. In addition to section 439 of the CRPC, the tripod test, now merits have to be considered. Category C, of course, then deals with, it's a progression where you deal with section 439 CRPC, the tripod test, and the requirements under the special statute. In most cases, it's known as the twin test, where the prosecutor has to be heard and the judge has to come, the concerned court has to come to a finding on merits that no offense as alleged or otherwise is made out against the accused in custody, who sort of filed the bail application. Malak, what are your views on this?
So I think the primary takeaway is can be put in 3 points. Number one, it seems that the court to some extent has disturbed the bail jurisprudence by
Absolutely.
sticking to something more than just a triple test, because you now added merits as a specific condition for grant of bail, especially for category B, C, D. Number two, to some extent, cases in which bail should have been for the asking upon filing of charge sheet, which is especially for economic offences, even cases where the offence is punishable with less than 7 years, now merits automatically gets added. And third, the most important is what the court was trying to evade with Siddharth and Amanpreet was that people should not rush and file anticipatory bail applications the moment a charge sheet is filed, because they wanted the person to be produced in court and apply for formal bail. With the until guidelines and the way they frame, it seems that this is not going to happen, and we are back to square one, where a person will still want to go for anticipatory bail, specifically in circumstances where he is wary of the fact that a bail being considered on merits will definitely be the death knell as far as his bail is concerned. So I think at this point, probably what may become more relevant is what is the material which he can now rely upon if he has to go down the bail route. What documents can he rely on to show that the merits are not made out against
Yeah, so
him?
I think what becomes relevant here is when we will now in the next series analyze the documents that are given to the investigating agencies during the course of investigation are not considered by them with the charge sheet as filed. Does the accused have a right to those documents? Can those documents be summoned by the accused at this stage and used at their bail argument?